CCPA, California Consumer Privacy Act. This act has brought a lot of heartburn to corporates. My dear friends, we're going to look into this. What are the cases in 2020 and what are the learnings from this? Now let's bring on before the screen is the different types of cases we are looking at. First type of cases we are looking at is about data breaches. So these are few cases which are mentioned on the screen. We talk about it later. It's about when there were data breaches. Now, private claim here, defendants here actually failed to take adequate data security measures and the plaintiff's personal information was subject to unauthorized access and exfiltration, theft or disclosure. So my dear friends, we are looking at this kind of cases little later in our presentation. The second type of case we are looking at is failure to comply with CCPA notice and opt-out provisions. You must be remembering, like in GDPR, we have opt-in provisions, while in CCPA has opt-out provisions. So these are three cases. The most renowned case which recently happened was about Zoom video communication. Zoom was used across the countries for webinars during lockdowns and this pandemic. Now, there are also similar cases against Zoom based on its alleged disclosure of personal information to third parties like Facebook, including the cases are like Kitpicker versus Zoom, Cullen versus Zoom, and Henry versus Zoom. We may not look into it, but just to mention, let's come to the first case. The first case we are discussing today, which happened in June of 2020, is Adkinson Nital versus Minted Inc. Now, what was the cause of action here? The suit against Minted.com arose out of a April 2020 data breach that resulted in exfiltration of 73.2 million records that included passwords, names, email addresses, and other information. Complaint alleges a violation of 179.8.50 by defendant's failure to prevent the unauthorized access and exfiltration, theft or disclosure of class members' non-encrypted PII. What were the claims for relief? Plaintiff and the class members, this was a class member suit, they sought injunctive or other equitable relief to ensure the defendant safeguards customers' personal information in the future. Plaintiffs will also seek further statutory damages if the defendant cannot cure the data breach within 30 days. So this was brought within 30 days. This class action suit was brought within 30 days. Next was Almafiel versus Ambry Genetics Corp. This happened in April 2020. Why was this brought in? This was brought in because a suit against a clinical genomic diagnostic company arising out of a January 2020 data breach that resulted in the exposure and exfiltration of sensitive personal and medical information of more than 232,200 patients. Oh my God, defendant began notifying affected patients only in April 2020, that is 4 months post the data breach. What was the claim for relief which was sought? The plaintiffs sought injunctive relief, written notice to defendant provision. Plaintiff state if defendant fails to respond to plaintiff's notice, letter or agree to rectify the violations detailed above, plaintiff also will seek actual punitive and statutory damages, restitution, attorney fees, costs, etc. and whatever court deems proper as a result of defendant's CCPA violation. Here, the defendant had claimed this under prohibition of unauthorized access and exfiltration, theft or disclosure of PII mentioned under the section 1739.158. Plaintiff also brings various claims for violations of California Confidentiality of Medical Information Act, California Medical Records Act, California UCL, negligence and unjust enrichment. So this was not only a suit which was mentioning CCPA, but other acts were also taken so that if the respondent misses out in one act, he can be caught in other act. Very clear of attorneys filing this return. Zoom video communication. Now this happened in April 2020. Everybody knows Zoom. We're using Zoom during pandemic for various webinars because it was free, but its origin will always be doubtful. Yet people were using it because massively popular and free to all. Later it definitely were having paid versions, but majority of the time till few members added it was free. So these claims had arisen out of a Vice Media report which was detailing unauthorized sharing and data vulnerabilities of Zoom. Now, this claim specifically alleged that Zoom collected personal data in the form of unique advertiser identifier data and shared that data with third party operators such as Facebook and LinkedIn without even notifying consumers or giving them the right to opt out. Now, this case is actually Boxbox versus Zoom, which also tries to characterize the share of information as a data breach or exfiltration, so that Zoom violated the CCPA. Now, plaintiff gave actual written notice of alleged violations to force Zoom to cure the alleged violations within 30 days. Now they had gone under this particular section 100B, 150A, 120B, where sharing with a third party without notifying or giving individuals a right to opt out. And the next was 150, where data breach or exfiltration violation had happened. Now, point to be noted is in this CCPA, you need to have notice given to opt out. If not, such kind of suits can be brought against you. And with the same suit, there are other violations of various acts like UCL, CLRA for negligence, invasion of privacy, and unjust enrichment can definitely happen. So please be careful when you're running an online business and when you're not providing any opt-out notices. Such kind of suits can be filed against you. The next case which is coming is of Sweeney versus Sweeney LifeOnAir Nital at April 2020. So this Sweeney versus LifeOnAir case, the cause of action had arisen against a house party, that is a video chat and a social media app, which were alleging that the company shared PII, that is personally identifiable information, which included personal identifiers, IP addresses, time zones details, phone carrier, device information, and unique advertiser identifier IDFA with Facebook and other third parties without notifying users or giving them to option to opt out. Similar to operative facts in the exactly as Zoom cases, the complainant focuses on use of Facebook software development kits, SDKs that is called. Now actually the plaintiffs violated 100B, 120B, 135A1, 135AB6, and which were of failure to provide adequate notice of collection of PII, sharing information with a third party without notifying or giving individuals a right to opt out, failure to provide a clear and conspicuous "do not sell my personal information" link on web page. Please note this is important. Without this, you are in non-compliance of CCPA. Failure to keep PII private. Now, if you are collecting PII of Californian residents, then you need to keep it private, or action can be brought against you under CCPA. And if the violation is more covered under other laws, the suit can be brought against you over there too. Now, the next case which has come before you is on Fuentes versus Sunshine Behavioral Health Group. This was a March 2020 matter. But if you look at this matter, the breach occurred for a period of almost 30 months, starting from March 2017 to March 2019, and then company puts a public notice in Jan 2020. Now, why was the cause of action brought in? It was because sensitive, publicly identifiable information, which includes medical information of patients of a drug and alcohol rehabilitation center, was searchable, findable, viewable, and downloadable anyone with access to internet search engine. See, such a humongous amount of loss to the victims of this data breach. Now, if you look at this proceedings, CCPA is mentioned towards the end of the page, but the page is covered by different laws, or the suit is covered under different laws. So by defendant, the Sunshine Behavioral Health Group actually violated CCPA by subjecting the non-encrypted, non-redacted personal and medical information of plaintiff and class members to unauthorized access and exfiltration, theft, or disclosure as a result of defendant's violation of its duty to implement and maintain reasonable security procedures and practices appropriate to nature and protection of that information. So this was where they went wrong. They didn't redact the names, they didn't encrypt the data which was available, and the data could be easily found right inside the Google or any other search engine. That was a humongous amount of deficit, gross negligence, and that's why the suit was brought against them. Now, this is the Ring litigation. There was a litigation going on in a Ring case. Now, Ring, what is Ring? So, let's first look at it. Now, this is Ring devices. This is the door ring. It started with that, but it made other devices too. Ring devices uses typically third-party trackers, and it disclosed a plethora of user PIIs with 4 analytics and marketing companies. Ring is a very personal private device which is kept outside your door for people to ring, and it monitors people coming in, people and people who are on your right out your door, or when you're not there, they go back. It records the logs for this. But Ring devices did not follow industry standards and did not require even basic measure like dual-factor authentication to use this device. Reasonable expectation of privacy was completely violated by failure of adequate security and disclosure of private and personal information to unauthorized third parties without the consent of Ring users. Now, what all they shared zone, device model, language preference, and unique identifiers in addition to sensor data exposing plaintiffs to huge amount of risk. It was completely negligent and breached its duty of care by ignoring consumer complaints, even if the consumer complained, or the contracts of privacy with the consumers were completely violated. Now, this doorbell was not a product fit for merchantability, as they were not secure and could not easily be accessed by third parties. Ring conceived unjust enrichment by selling its products to the customers. Ring violated CCPA by collecting personally identifiable information without providing notice to consumers, and by not providing consumers with an option to opt out. So Ring was completely in a wrong side of the law. So Ring remains violating 100B, 120B, that is use of PII without providing notice, and 120B, failure to provide notice to consumers regarding their right to opt in. So Ring is a very interesting case. You need to observe, because IoT devices are here to stay, and what pitfalls Ring had faced, the other IoT devices may face. So it's very important to note this and follow this litigation as it progresses. Next is Hannah Anderson and Salesforce.com matter, where the cause of action was brought around because the PII of customers of Hannah Anderson was scraped through a malware on Salesforce. Now, this is a very typical case. The case is where there was a malware on Salesforce cloud-based platform used by Hannah Anderson, and someone implanted malware in Salesforce, which actually scrapped data from Hannah Anderson. Include the data was like customers' names, addresses, credit cards, numbers, credit card expiry dates, and CVV codes. Now, when law enforcement found unauthorized information on the dark web, they immediately informed Hannah Anderson of the breach. that occurred from September 2019 to November 2019. So huge amount of time where the data was stolen using malware. Now here, if you look at this, Hannah Anderson was a retailer of high-end children's apparel, and actually Salesforce was the provider of the cloud-based services. Now here, if you look at this typical case, both failed on adequately safeguarding PII of users. They did not warn of inadequate information security practices to users. Effectively, they didn't monitor the platforms for security vulnerabilities and incidents. Defendants' conduct amounts to negligence here and violates several California statutes. It's not only CCPA. At least 10,000 Californian residents and multitudes nationwide were affected by this breach. Some of this information is still being sold on the dark web. Imagine the depth of this breach. That's the information is still available, and sometimes children's information is available, parents' information is available, and this possess a lifetime risk of identity theft to the users of Hannah Anderson. See the seriousness, it is lifetime risk to the users of Hannah Anderson. Hence, this Hannah Anderson matter is serious, and this can be happening with other companies, so people need to observe and check what's happening with your data and what's happening with the data on your cloud or the cloud service providers, security, reasonable security, what they're implementing. So lastly, we are looking at a case which is Deborah Ash versus Yodlee. And see, Yodlee is a financial data aggregator. Everybody in the States is aware of this organization. It connects with all your banking accounts, your mutual funds, your any financial instruments you have on your name, your property, and it gives you data in one single screen. So it shows you what's your debts, what's your asset value, how are you progressing, what insurance you have, etc., etc. Now here, the class action against Yodlee was brought alleging that it used its API to access plaintiff's bank account and sensitive personal data without her knowledge or consent when she used her PayPal account. Now here the complainant alleges a violation of 100B for failure to give notice that the business was allegedly collecting personal information. Now Yodlee is a big player, and this is an interesting case where many US citizens, many Californian US citizens can get affected, and hence the violation, the relief for violation of Stored Communication Act, Computer Fraud and Abuse Act, California Unfair Competition Law, California Comprehensive Data Access and Fraud, California Anti-Phishing Act, Unjust Enrichment and Common Law Invasion of Privacy. Huge number of laws were actually broken by Yodlee INC over a period of time. This case remains interesting to see what happens in the CCPA domain. As 2021 approaches, my dear friends, you need to be aware of the CCPA obligation. I'm Prashant Mali here, cyber and privacy lawyer, talking to you. And my last advice would be, with the new CCPA 2.0 being passed and with the new regulator coming into picture, you need to take CCPA 2.0 or CCRA compliance as of today. Follow the cases and gain wisdom. Thank you for listening to me. Thank you again.